This is Constitutional Rights in Black and White.
Before the 2008 primary elections, a nonprofit corporation named Citizens United created a film titled Hillary the Movie. The film advocated against then-Senator Hillary Clinton, who was running for the Democratic presidential nomination. The film therefore met the technical definition of an electioneering communication, which was regulated by federal campaign finance law. Specifically, federal law prohibited corporations and labor unions from using their general treasury funds to create and air such communications if they were publicly distributed through broadcast communications. Citizens United was partially funded by for-profit corporations and used that money to make the movie, which meant that it was prohibited from airing it. Citizens United sued the Federal Election Commission, and the case went to the Supreme Court, where Citizens United argued that federal campaign finance law was suppressing its speech based entirely on its use of corporate funds and was therefore unconstitutional under the First Amendment. The Supreme Court agreed. This was, according to the court majority, a ban on corporate speech, and the First Amendment does not allow political speech restrictions based on a speaker's corporate identity. Wait, said the government, that's a big change. Campaign finance law always recognized that corporations and unions are different from individual people. Corporate access to large amounts of institutional money can distort elections and needs to be regulated. You are partially right, said the court. Congress can still regulate direct contributions to political candidates and political parties because of the risk of political quid pro quo corruption, that is, dollars for political favors. The government has a sufficiently important interest in the prevention of corruption and the appearance of corruption to support such regulation. But the same isn't true for independent expenditures like this one, which were made without coordinating with a candidate or party. Hold on, said the government. The court already decided in an earlier case, Austin versus Michigan Chamber of Commerce, that the government has a compelling interest in preventing the corrosive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form. That anti-distortion interest is also a kind of anti-corruption interest, and it supports a ban on corporate expenditures. Not anymore, said the court. Austin is not well-reasoned, and Austin should be and now is overruled. The only kind of corruption that justifies restrictions on corporate speech is the risk of quid pro quo, which is a problem only for direct contributions, said the court. Independent expenditures, including those made by corporations, do not give rise to corruption or the appearance of corruption. Wow, said the government. That's pretty much the end of campaign finance law as we knew it. So you're saying any organization, corporate or otherwise, can spend as much money influencing an election as it wants to without limitation or constraint, as long as it doesn't coordinate with candidates or parties? Basically, yes, said the court. Campaign finance law, as we long knew it, ended with Citizens United, but not because of the holding for which it's infamous, namely the protection of corporate campaign spending under the First Amendment. Instead, the case's greater significance is its decision to narrow the constitutional definition of corruption strictly to quid pro quo transactions and the appearance thereof. This meant that the government could restrict only campaign contributions made to candidates or political parties. Under the First Amendment, it now cannot limit independent expenditures by anyone, by any group. Because independent expenditures cannot be limited at all, this has permitted money to flow to the least regulated, least restricted outside groups in ways that aren't subject to limitation, or sometimes even disclosure. Because of Citizens United, American elections are now awash in millions of dollars spent by super PACs and shadow groups without limits on donations, often without basic disclosure about where the money comes from. Okay, let's read the case. Citizens United was about a rule in campaign finance law that prohibited corporations and unions from using their general treasury funds to engage in campaign speech. The decision changed two big aspects of federal campaign finance law. First, the law had always treated corporations and labor unions very differently than individuals. That changed. Second, the law had allowed restrictions on both direct contributions and independent expenditures. That also changed. Citizens United decided that corporations, or for that matter, any group or organization, cannot be treated differently from individuals when, nor restricted from, making independent expenditures, even though they expressly advocate for the election or defeat of a candidate. The case was about a film called Hillary the Movie, which Citizens United sought to release right before the Democratic primaries in 2008. Senator Hillary Clinton was a presidential candidate in these primaries, and the film was critical and pejorative. It thus qualified as a restricted electioneering communication, which is defined as any broadcast, cable, or satellite communication that refers to a clearly identified candidate for federal office within 30 days of a primary or 60 days of a general election. Because Citizens United used for-profit corporate money to make the film, it was barred by federal campaign finance law from airing it. Specifically, it was barred by the Bipartisan Campaign Reform Act, otherwise known as McCain-Feingold, and under the earlier Supreme Court decision, Austin versus Michigan Chamber of Commerce in 1990. The original issue in the case was a narrow one: whether Hillary the Movie was publicly distributed for purposes of the regulation, because Citizens United released it through video on demand. But during oral argument, the conservative justices appeared flustered by the government's assertion that the government could prohibit the use of corporate funds for express advocacy in book form. The court ordered new briefing and re-argument on the question whether Austin should be overruled. In defense of the law, the government pointed out that corporations that want to advocate during campaigns have other speech options. For example, they could create a separate political action committee, or PAC, that doesn't use general treasury funds. The court held that the PAC option did not save the speech ban from unconstitutionality because PACs are burdensome and expensive and not equivalent to corporations speaking for themselves. Although time, place, or manner restrictions on speech are permissible under the First Amendment, the court refused to categorize campaign finance laws in this way, writing that if the law applied to individuals, no one would believe that it is merely a time, place, or manner restriction on speech. It was statements like these that inspired the most prominent criticisms of the court's decision for ruling that corporations should have the same speech rights as people. The leading case governing campaign finance law before Citizens United was Buckley versus Vallejo, decided in 1976. Buckley upheld campaign finance restrictions on express advocacy, meaning campaign speech with magic words of advocacy like vote for, elect, support, cast your ballot for, Smith for Congress, vote against, defeat, reject. Most importantly, Buckley created the constitutional basis for restricting campaign speech. It held that the government had a sufficiently important governmental interest in the prevention of corruption and the appearance of corruption to support restrictions on direct contributions to candidates. The Buckley court identified the risk of quid pro quo corruption as the paradigmatic form of corruption, and the concern that large contributions could be given to secure a political quid pro quo. Buckley also struck down restrictions on independent expenditures by individuals, but it did not directly address the distinction between corporate and individual speakers, or the prohibition on corporate expenditures under federal law. Over 3 decades after Buckley, the court slowly expanded this anti-corruption interest to emphasize the perception of corruption, distortion of the process by corporations, selling of access and influence. Specifically in Austin, the court identified a compelling government interest, sufficient to uphold the ban on corporate independent expenditures, in preventing the corrosive and distorting effects of immense aggregations of wealth that are accumulated with the help of the corporate form and that have little or no correlation to the public's support for the corporation's political ideas. By striking down Austin, Citizens United positioned itself as ending this expansion and returning to what it saw as Buckley's original narrow conception of corruption. Writing for the court, Justice Anthony Kennedy fleshes out this holding in a number of ways. He reasons, for example, that Austin might permit the government to prohibit a corporation from disseminating a printed book containing its political views. He takes a structural view of the marketplace of ideas, focusing on the amount and flow of political speech rather than the identity of the particular speaker and any formal rights they might claim. He emphasized Buckley's reasoning that the government has a substantial interest in combating corruption, but it has no legitimate interest in equalizing the relative ability of individuals and groups to influence the outcome of elections. This reasoning essentially rules out the use of campaign finance law to address inequalities of money and power in political speech. Or as the court put it, the First Amendment's protections do not depend on the speaker's financial ability to engage in public discussion. The most consequential doctrinal move in Citizens United is its renewed emphasis on a sharp distinction between direct contributions and independent expenditures. The court quotes Buckley for the proposition that the absence of prearrangement and coordination of an expenditure with the candidate or his agent alleviates the danger that expenditures will be given as a quid pro quo for improper commitments from the candidate. The court concludes that only direct contributions pose a risk of quid pro quo corruption, whereas independent expenditures categorically do not. The court declared that we now conclude that independent expenditures, including those made by corporations, do not give rise to corruption or the appearance of corruption. As a result, independent expenditures cannot be limited at all, whether made by corporations, unions, or any other organization. Notice that as an empirical matter, this is clearly questionable. Just because independent expenditures are not made in formal coordination with a candidate or party does not mean that politicians do not know about them or recognize them as support that invites reciprocation. Independent expenditures, especially when they are very large and well known, obviously can be the basis for an unspoken quid pro quo. The premise is also impossible to square with the court's earlier decision in Caperton versus Massey Coal Company. In Caperton, the CEO of Massey Coal Company spent $3 million in independent expenditures to assure the election of a sympathetic justice to the West Virginia Supreme Court. That justice then cast a decisive vote in Massey's successful appeal of a $50 million jury verdict against it. The U.S. Supreme Court, in an opinion also written by Justice Kennedy, only 1 year before Citizens United, decided that those independent expenditures created a sufficient risk of actual bias that the justice was required to recuse himself in that case. The Citizens United Court, however, distinguished Caperton as a rule about judicial recusal and a litigant's due process right to a fair trial before an unbiased judge, rather than one about restricting campaign spending. Although Citizens United also challenged the disclosure and disclaimer restrictions in campaign finance law, the court upheld these types of restrictions, reasoning that disclaimer and disclosure requirements may burden the ability to speak, but they impose no ceiling on campaign-related activities and do not prevent anyone from speaking. As a general matter, disclosure requirements have been regularly upheld and, constitutionally speaking, are the safest type of campaign finance regulation, though they too have come under increasing attack since Citizens United. The court ends by celebrating the deregulation of the market for political speech. The First Amendment underwrites the freedom to experiment and to create in the realm of thought and speech. Citizens must be free to use new forms and new forums for the expression of ideas. The civic discourse belongs to the people, and the government may not prescribe the means to conduct it. There is, of course, a contrary view that informed campaign finance law for decades, namely that the market for political speech requires regulation to function well, just like many other markets. Regulation can help ensure, for example, that the wealthiest speakers cannot drown opposing views. After Citizens United, however, this view of salutary market regulation does not apply in campaign finance law. Citizens United transformed campaign finance law, but not for the reasons that most people think. Public outrage about Citizens United focused on corporate political speech and the treatment of corporations as First Amendment speakers on par with individuals. President Obama called the decision a major victory for big oil, Wall Street banks, health insurance companies, and other powerful interests that marshal their power every day in Washington to drown out the voices of everyday Americans. Ironically, this aspect of Citizens United turned out to be relatively minor. Corporations were already allowed to spend their money on sham issue advocacy, that is, ads that criticize or promoted candidates but stopped short of using Buckley's magic words of express advocacy. And big corporations were not especially eager to spend their treasury money on political advocacy. Indeed, federal restrictions on corporate electioneering were actually supported by a number of big corporations, including General Motors, Ford, Monsanto, Time Warner, Dell, Cisco, IBM, among others. Citizens United's lasting significance in campaign finance law was its decision to narrow the definition of corruption as a basis for campaign finance regulation. It limited the government's interest in preventing corruption to the risk of quid pro quo transactions involving only campaign contributions directly to candidates for office and political parties. This move constrained not only the regulation of corporate electioneering, but regulation of all campaign finance spending, including by super PACs, wealthy individuals, and non-corporate entities. Removal of long-standing restrictions on independent expenditures permitted money to flow to the least regulated, least restricted groups that are not subject to limits, and sometimes not even disclosure. It created a reverse hydraulic process in which money shifts away from candidates and parties that are more regulated and accountable to outside groups that are barely regulated at all. Those outside groups now spend millions on electioneering without limits on the money they collect from donors, and often without disclosure of where the money comes from. And after Citizens United, there appears to be nothing that Congress can do to reinstitute meaningful restrictions.
Our deepest thanks to Professor Michael Kang. Professor Kang is the class of 1940 professor of law at Northwestern Pritzker School of Law.
He is a nationally recognized expert on campaign finance, voting rights, redistricting, judicial elections, and corporate governance. In 2021, he was appointed by President Biden to the Presidential Commission on the Supreme Court of the United States.
We're grateful that he took the time to share his work and expertise with us.